With my lord's permission, may I mention civil appeal, my lords, 2123 of 2024, my lords.
What is it about?
My lords, the same was notice was issued on 5th of April.
What do you want?
My lords, I wanted to be listed on 17/4/2026, the tentative date, my lords. It's been dropped, my lords, throughout the year.
Lords, may I mention a small matter? Lord, I'm simply seeking permission to file a rejoinder in SLP criminal 493.
No problem.
Obliged.
Item 1.
Is it 8 months or 6 years?
It's 8 months. The office report is wrong, my lords. It's 9 months. Now 10 months is finished. There's no overt act. He in fact took the victim to the hospital and donated blood for the victim.
Notice 4 weeks. 2 weeks.
Item 2.
May I please, Lord? My Lord, the SLP, my Lord, was dismissed, my Lord, on the submission of my learned friend, my Lord, that billable warrant has been issued, my Lord, and process under Section 82 has been initiated, my Lord. After dismissal of the SLP, my Lord, I have contacted petitioner, my Lord. Only warrant has been issued, no proceedings have been initiated under Section 82, my Lord. And therefore, my Lord, on that very day also, my Lord, I have submitted that, my Lord, to my knowledge, this thing has not happened. And that is found to be false, my Lord. Lordship may kindly give me liberty to file an application for revival of this SLP, my Lord. Lordship has said that liberty is always there, my Lord. That's why I filed this application. And kindly appreciate, my Lord, everyone has been granted anticipatory by my Lord. He is the person, my Lord, Pramod Kumar.
NBWs are issued or no?
Pardon, my Lord?
NBWs are issued or no?
Only warrant are issued, my Lord. I have asked, my Lord.
NBWs are issued or no?
To my knowledge, my Lord, he said only the order says only warrant, my Lord. My Lord.
You're only saying, what does NBW mean?
Yes, my Lord.
Warrant of arrest is NBW or no?
Yes.
Then that's the end of the matter.
No, my Lord. What I am submitting this, my Lord. Kindly appreciate, my Lord.
Thank you.
Everybody has been granted anticipatory by my Lord.
Thank you.
I will station also physical appearance.
Physical appearance. No.
I'm so grateful.
I'm so
Lordship, High Court, not without even issuing notice to me, not without hearing me, reduce the compensation which is not statutory mandated.
Between the court and the.
But the question is not the statutory mandate is 20%. Your Lordship have clarified in Muskan Industries. Let me kindly have the judgment passed by this court.
Notice. State of Rajasthan, उनका presence रख लीजिएगा. Notice to private respondent.
May I request for stay of the operation? Right? In the meantime, he'll deposit the entire amount.
Let him deposit.
Very well. I'm great.
Lords, I beg to appear for the UT of Jammu and Kashmir. There are 3 shortcomings of my petition. One is delay in filing this SLP, which is 106 days, refiling 11 days, and I've been ousted by the Honorable High Court on the basis of delay of 596 days. I don't have a better explanation than what I had before the Honorable High Court. However, my lords, there is one law point involved.
What is the law point? Tell us.
My lords, this respondent, who is now deceased, represented through LRs, he was appointed in the year 1996.
What was he working as?
My lords, it was a class 3 post, sanitary inspector. My lords, may I just make the point, my lords? 96 he is appointed, 2008. Grateful, my lords.
Delay in filing SLP is condoned.
And refiling, my lords.
And refiling.
Grateful, my lords.
Item 5, Your Lordship. This is a legal aid matter, Your Lordship. The
14 years old.
Your Lordship, but the story of the prosecution is highly doubtful, Your Lordship. They
Which witness's testimony renders the genesis of the prosecution story to be false, doubtful.
Your Lordship, the prosecution story is that 2 people entered in the room through a window of 1 feet by 1 feet at the night, and no broken window was seized. Your Lordship, it's a, and the sister of the victim who was sleeping along with her in that room, she turned hostile. The brother of the victim, Your Lordship, he was sleeping in another room. He doesn't know anything about it.
Assuming that it is a case of consent, let's proceed. Is there any doubt about the age?
Your Lordship, the age is, Your Lordship may consider that after 14 years, if
No, that of course, your right is there.
But washing prior to completion of investigation, the demand, my lord, there is a recording of the demand, and my lord, the
Notice.
My lord, there is no demand, my lord, no acceptance, my lord,
There
no
is-
presence,
I'll reply.
no recording, my lord. Nothing against me, my lord.
Why did
This
you
one number
stand
one.
here? Why did you stand here? Notice.
Wait.
File your reply.
Wait.
2 weeks, 2 weeks. Yeah, 4 weeks. So.
It's item 7, there is a delay of 490 days, and the reason is, madam, it's a legal aid matter.
No problem, delay condoned.
Yes, so now, the error in the High Court judgment is that the High Court has proceeded as if his salary is 77,000.
Notice.
I'm ready.
Dasti kar dena.
I'm ready.
138 washing lords, 3 things I want to say. I have absolutely no relation with the complainant. I have been residing in Rajasthan throughout. In the complaint which he filed, my lords, he says he paid to my sons. How he paid, when he paid, there is absolutely, my lords, no description in the complaint.
Notice.
Lords, I am praying for a stay because, my lords, complaint is proceeding against me. It's only for 20.
Complaint.
Lords, I have to go to Ahmedabad. Lords, I am staying in Rajasthan. I am a 64-year-old man.
Seek exemption. And we'll give a short notice, not deportation.
So Lordship may say notice on interim relief, I'll seek exemption.
Not interim relief.
Obliged.
दो हफ्ते के बाद डेट.
Item 9.
Please, my lords. My lords, the petitioner has been convicted under section 302 IPC. My lords, this is a case of blind
Conviction under
302 IPC, my lords. Obliged.
Item 10.
1 minute. हाँ?
Instruction of the council.
उनका हाजिर लगा लीजिएगा नेक्स्ट वीक के लिए कर लीजिए.
Item 10 plus 43.
My lords, I'm seeking a passover in this matter. My lords, it may be taken along with item 43. Both the matters are arising out of same inquiry. Obliged.
11.
My lords, I'm led by Mr. Rothke in this matter. He's just on his way to. I'm led by Mr. Rothke. I'm just seeking a short passover.
I have no objection. Lords. This is that same matter
We know.
which your lordship had heard at some length earlier.
So we were to know what happened in those proceedings.
That affidavit I filed. I filed an affidavit bringing that on record. There are 2 affidavits which I filed.
Lord, the matter may be taken up on Passover.
Very well.
Obliged.
Ms. Divani.
I mean, in compliance to the last order, my lord, I approached to the respondents. But, my lord, there was no any response, my lord. And I am ready to deposit entire due amount, my lord. Let the order be passed, my lord. This is a small booth, my lord. Poor person, my lord. And it has...
The respondent, Chandigarh administration, there, see, it is difficult for them to settle the matter. They are not ready to settle the matter.
Who is not ready to settle?
Last time your lordship said.
Who is not ready to settle?
The department.
Sorry, department is not ready to settle.
Because they may be given some time to file counter.
Who's in possession?
See, we are in possession.
You means
You see, administration.
Administration.
Yes.
Mr. Singh, are you in possession?
My lord, I am not in possession, my lord.
Then there's nothing.
And I have deposited entire amount, even my lord, and submitted my lord, draft of rupees 4,60,000, my lord. I am ready to deposit entire amount.
Executed, was cancelled or
Cancelled loan back.
you return the payment along with all back with interest.
My lord, have a page 5, my lord. The
Yeah,
condition is, my lord, word is used may cancel, my lord. Because I was not.
They have a right.
My lord,
Sorry, well, we are not inclined to interfere with the doomed judgment, but however, direct impugned judgment insofar as the rejection of the petitioner's claim is concerned, but however, direct that the amount of these 4 lakhs, na? Or 1,05,000.
4,60,000.
Your lordship may kindly see the
The amount deposited by the petitioner.
office report may be kindly seen.
He-
They have not deposited any.
The amount deposited by the petitioner, if any, at the time of allotment, be refunded
Office report.
within a period of
Deposited, not
8 months.
deposited anything.
Yeah, so 8 weeks from today.
My lord, he's a poor man, my lord. Kindly see page 5, my lord.
Thank you.
Cross 2. Page 5, cross 2, my lord.
Thank you, sir.
Your Lordship, I'm seeking a short possible.
Paso.
Let me. Was 14, the last date in 14, your lordships had referred the matter to mediation. My lords, 25th. My lords, unfortunately, my lords, we've not been able to do on that. So 25th of February order, my lords, your lordships had directed us.
Mediation was not successful.
So.
Not, then you'll have
Not-
One
not
thing,
successful.
there are 3 people have given the power autonomy to somebody else. I said that bring him, so mediation can be fertile and every all the time it can be settled it. Because I
We revoked that power of attorney. That person has now subsequently gotten mixed up with them, which is why they want him on board, and
I
that's
said, I
another reason that
implicated because I said that kindly.
the presence
bring
of that person.
They are not.
He is not a
bringing-
party
the
to the
person who filed the 711 is not party to the proceeding. I said bring him, settle it every time, because one person will be left, then I'll settle with them. Another person will.
That person who has been left, may I just put it across? The
I can
person-
say that.
One second, sir. So, my lords, there
the
are,
person who has been left.
the person who has been left is the nephew and son of one of the parties that I'm representing. I'm representing 3 persons.
No, you get them here, no problem.
The problem, I'll point out the problem. The problem is this, that
He's
he's not a party. He is not a party to the 711 application.
He a party here before us.
He is not a party before this honorable.
Before
And in fact, that person who we had given the power of attorney, who they want to bring on board now, my lords, is the person whose power of attorney we've revoked, number 1. Number 2, my
What
lords,
is his name?
my lords, his name,
Sakharam Boyar.
Sakharam, Sunil Sakharam Goy.
I filed implement application.
No, you don't have to do that.
It has to be tested on my government's, my lord, so 711 application.
And Melons, he is the one who has executed sale deed, further sale deed also. He is the party and he is the power of attorney holder for that
My lords,
execution.
my 711 application has to be tested only on the contents of the
Person who
application
711 filed.
and their.
Yes.
And
Yes, Melons.
what is the date of the agreement?
Date of the
1984.
agreement is 21st August 1984 is the agreement. Agreement of sale. Sir, Melons.
One by one, let's deal with
Yes,
it one by one.
yes, Melons.
What is the date of the agreement? 84. When were the proceedings initiated?
Melons in the year 2002.
22, 38 years later.
When were the proceedings?
Yes, sir.
Melons,
What does 711 say? So what are the ingredients of 711?
Yes, Melons. Melons, Order 7, Rule 11 says.
Correct, read it.
Yes, Melons.
What are the essential ingredients
Yes, Melons.
barred by law?
Barred by law. By
So therefore, law of limitation applies or does not apply.
Correct.
Yes, Melons.
If a cause of action which arose in the year 1984,
Yes, Melons.
proceedings initiated in the year 2021 or 2022,
Yes, Melons.
is it barred or not is what we are asking us.
Yes.
No.
No, it is not.
Why?
Minus come to the paragraph 257, page number 257 of the plaint. They themselves say that my cause of action arose 2018 only. They said that. I said that. In High Court, they said that my cause of action arose in 2018 when they.
Do we have to read the plaint or do we have to read annexures appended with the plaint? We have to read the cause of action in the plaint. No?
Yes, Milord.
See, we don't have to see anything here. So if we read the plaint.
May I please, Your Lordship, I may take you to the page number 231 of the SLP Milords, wherein the Order 7 Rule 11, the order has been passed by the trial court. In that para number 9,
711 का reject कर दिया है.
Milords, no.
Question of law and fact. It cannot be.
Milords, there was multiple proceedings Milords have held Milords, and wherein we were the party of it. Milords, I would like to take you.
Only my lordship, I want that. You want to settle
talk.
it, everything would be
You cannot settle in this manner. What is that you wish to settle? You tell us.
Yes.
May I please, Your Lordship?
I can.
Both can't have two counsels arguing, please.
Sorry, Milords.
You are a lady, so therefore we allowed you to do that. You can't judge you. See, your senior cannot just rise up and argue this. You choose who is to argue.
No, he is.
You tell us, do you want any settlement or no?
Milords, settlement is not possible. Milords.
Not possible.
Milords, they are offering only 10 lakhs. Milords.
What is the point of bringing somebody else?
Settlement is not possible.
So how much do you need?
Milords, if
What is your demand?
Milords, the demand as per the suit is Milords 1 crore 52 lakhs. If the suit has been filed in the year 22.
Okay, what's the reasonable demand?
Milords, it's the 50-50 we are 50-50.
crore, she wants 50 lakhs.
So we
Not Milords.
argue the
50
matter.
lakhs,
Milords,
that they may offer us 10 crore. Milords, the land is of 8,000. Yes, Milords, the land is of 8,855 square yard. Milords.
1984 agreement to
Milords,
seven,
1984
never acted upon, no proof of
the
payment,
prime location, Milords, and
no proof of payment.
Either land
Express
Milords
act.
or the money Milords of the that nature, Milords.
I'll argue my application, but I'll argue it here before this one.
And Milords, I'll take you to the application, Milords. The application has been filed by me, Milords, before the SDO, Milords.
May I make a suggestion, Milords? May I make a suggestion? Lordship's Milords, my learned friend is clearly not keen to settle the matter. Milords, these demands are
Milords, it is not like I'm
incredible. I'm only saying that your Lordships may have it, Milords. I'll argue it out. I'll have to show 2-3.
No, we are reserving judgment. I
Very
got written submissions. What is there in it?
Very good. Correct. I'll point it out. I'm grateful.
Simple.
May I please, Your Lordship, I would like to show you some documents.
Last opportunity for you to settle. Should you wish to.
Milords, the offer should be little this thing, Milords. It should be.
We'll pass over. Go and
10 lakh offer is not, Milords.
Go out, talk amongst yourselves, and come out. If it is workable, very well. Otherwise, judgment reserved. Then we have gone through the file. We know the facts.
Your Lordship, I appear for the order and right. We have inter se settled the matter. I filed this compromise agreement. But it's filed only yesterday, may not be on your Lordship's file. Because I have a hard copy. I served already yesterday. I have the hard copies.
Who are you?
I'm owner and driver settling with the claimant. They, of course, they are relatives. One of my brother has died. Lordship may be remembering. While
what do you say?
No, we are exonerating him completely.
Yes, my lords. My lords, on 19th of March 2026, my lords has given them the direction to deposit the amount, my lords. Thereafter, my lord, the matter was listed on the last day. They have
the judgment has to be set aside.
Yes,
but your Lordship,
there is a compromise.
In terms of
your Lordship, we don't have any objection. He will be withdrawing.
We will be withdrawing that claim.
Claim petition. They are withdrawing the claim petition.
As per the agreement.
Yeah, application is the diary number?
No, this is not, there is no, this is a compromise agreement.
You have not
filed. No application. Acknowledgement of filing proof is there.
Diary number.
Filing proof is there.
Diary number will be saved.
Diary number will be
a
saved.
e-filing number.
Calculation. No, it is not there. Must
It
be-
may not be there because it's filed only yesterday. Yesterday was false. That's it.
Then we'll record his statement.
That's,
Yes,
Lordship,
that's what I-
absolutely. He is withdrawing.
Seeks permission, yeah, submits that petitioner. And then comes to the respondents. That is the claimant, appearing for the claimant.
Claimant is 1, 2, 3. Arun.
Claimants 1, 2, 3, namely naam kar देंगे. Colon, the driver, respondent number 4, and the owner, respondent number 5, naam aa jayega, have intersea settled the matter. The claimants do not press and do not oppose the present issue. So also the owner. The liability was fastened on.
Well, initially the
Insurance
liability
company.
was
That we absolved.
Yes.
In the instant case, the liability was fastened upon the insurer. In view of the fact that the claimants have entered into an out-of-court settlement with the owner, and that they pray for withdrawal of the original complaint. Original petition, original petition, claim petition, being the number page 127, title is so and so, which is permitted by this court, the award passed by the tribunal dated 12th of May 2016, as affirmed by the High Court, with a judgment dated so and so, is quashed and satisfied. Commission stands disposal.
My lords, may I seek one direction? My lord, I have already deposited the money with
The amount deposited by the insurer is permitted to be refunded. Deposited by the petitioner is permitted to be refunded to the petitioner along with the interest.
Milords, I appear for the petitioner at N16.1. Milords may recall, Milords, on the last date of hearing, learned Attorney General appeared and requested this on record that they will be filing a composite report, Milords, in respect to all the matters pending in this regard. Milords, this is the matter, Milords may recall, the High Court has directed us to deposit a 50% amount of the award, interim award. So, Milords, the report, I guess, has not been deposited, Milords, till date.
Your Lordship, may I please submit? I appear on behalf of the Office of the Attorney General. The report that we had asked for from all the high courts, actually the data was in different formats. We requested
How much more time? 2 weeks more time.
Your Lordships, that may be appropriate.
What's your good name?
Your Lordship, Karthik Agarwal.
As paid for by Shri Karthik Agarwal, matters adjourned list on 11th Monday.
Your Lordship, if I may please submit just one request, because we have been requesting the Honorable High Courts for data in a specified format. Your Lordship, please make it part of the order that in case a request goes from the Office of the Attorney in that format. Otherwise, it is not being.
We are informed that the authorities, including the high courts, are not responding to the information sought for by the Office of the Attorney General.
In the particular format.
More so in the prescribed format. In the format so prepared by him. So as such, we direct all concerned to forthwith comply with the order. Item number 3 shall be open for the Office of the Learned Attorney General to immediately communicate with the authorities.
Your Lordship will have it in first week of May. Any fixed date, Your Lordship will have the report filed by then. It's 15th April, Your Lordship said 2 weeks.
My lord, the question in item number 16, there should not be any stay. My lord, there should not be any stay. My appeal is still pending, my lord. They need to give money to the victim, my lord, in this matter. So at least, my lord, there should not be a stay in the appeal.
Yes. We clarify that we have not stayed the proceedings.
Milords,
It shall be open for the authorities below to continue with the proceedings, intercede the private parties.
Milords, this order may be recorded at qua item 16, Milords. Item 6, ma'am, what has actually happened is,
Both
Milords.
these matters, thank you.
No, Milords, item 16.1 was the main matter, Milords.
Thank you.
Milords, stay was granted by Milords only, Milords, by order dated 13th of August 24.
Interim vacated.
Item 17.
Lords, item 17, Milords, mediation has failed and respondent number 2 has not filed her wakalatnama yet, Milords.
No, but then,
Mediation report has come.
so that's all right, but it can't, it's not a case of quashing.
No, Milords, divorce has already been granted in Australia.
But that's all right, it's not a case of quashing.
No, Milords, the only reason the High Court, the quashing qua other accused have already been done by the High Court, Milords.
Because the other, you are the petitioner, husband, huh?
Please, Milords, the only reason No, Milords, the divorce has already been granted way back in 2019 in
How does
Australia.
that advance your case?
Milords, the High Court has only rejected my quashing on the ground that I was not present in India and I have not cooperated with the case, Milord. That's the only reason given.
The lookout circular was issued against you.
Please, Milord, that was stated. No, Milords. Milords, one request, Milords. Milords, just one request. Milords, anticipatory bail was granted to me. I am an Australian citizen. I traveled to Australia and therefore the High Court says that you did not took any permission from the trial court for traveling abroad, Milord. That is the only reason my quashing has been dismissed, Milords. Milords, may kindly see there is no case made out. Divorce has been granted. The marriage was in India. Thereafter, the parties stayed in Australia. Both the parties have remarried, Milords. The complainant has a daughter also from the new marriage, Milords. There is nothing in this case, Milords, now. The only reason given by the High Court was that I was not in India when the case was being heard. That is and I did not take permission of the court to travel abroad.
Your base case you are not arguing. Your case, you should argue that the complaint is not lodged by the wife.
Please, no, this is by the father-in-law.
So that you are not arguing.
Lords, I was coming to that, Milord.
Coming to that.
Lords, I was coming to that.
Yes, gentlemen, why should we not quash?
I am for appearing for the state police. I am appearing for the state police. It's a Chandigarh administration. We have not done.
Parvinder Singh, who's there?
Last occasion, Your Lordship directed them to go to mediation. Mediation report.
Who's there, Parvinder Singh?
Parvinder Singh is the father of the complainant, Milords.
Who's he?
No, they have not filed the wakalatnama here, Milords. They have participated in the mediation. We have interacted. Their lawyer was also present in the mediation. However, they have not filed their wakalat till now.
No, but how could they participate in the mediation?
Milords, they were informed, Milords.
What is the name of the advocate?
Milords, I don't remember offhand, Milords, but there was some lawyer who was present, Milords.
I conveyed a message to him.
You know him? You know him, no?
Chandigarh administration.
We are
no, not Chandigarh administration. The lawyer for the private party. Service ho gaya na?
Yes, sir.
Service complete.
Today.
Item 18.
My Lord, item 18, on 11th of March, I appeared before my Lord then and the mediation was in progress. Now the report came that it has been failed, my Lord. On that date also, I pointed out there that yes, we offered the amount, just double the circle rates, my Lord. Just to save the 20 families who are living in the property since 1939. We offered this much, even just double what the circle rate is there, my Lord. Now such a hardened attitude is there on the part of the respondent. No, I will. Now only we wanted to save the family by paying the price of the land. What else they want, my Lord? Ignoring what my case, my Lord. Once I am offering the price of the property, my Lord will have the report for what is the circle rate and what is the value of the property. I'll pay the same, my Lord. I'll pay the same, my Lord. We are living in the property since 1939.
This is the circle rate and market value. There's a lot of difference. 8 times difference at least. This is what my instructions are.
My Lord, in the village, it can be 8 times.
The gap is.
With the little knowledge you and we do have in the village, remote areas, 1,000 kilometers from here, can it be there, my Lord? Circle rate, and I'm paying the double the same. What more do you need? And I leave to the gracious wisdom of this court, my Lord, whatever the price which my Lord takes there.
Are you ready to pay?
We were ready to pay 20 lakhs. We have
He
even
will pay
gone.
you 20 lakhs to hand over possession.
My Lord,
He will pay you 20 lakhs.
my Lord, in fact, we have gone to the extent of paying 32 also. We increased that. And if my Lord,
Whatever is your highest offer, he will
my
pay.
Lord, my difficult, my Lord, my Lord has that only just to save the families, just to save the hutments and houses. That's why I offered, my Lord. That is the only thing, my Lord.
We know that it can be dismissed in 1 minute. All throughout he has lost. We know that.
Just to save the families, my Lord.
1 minute.
My Lord.
See, whatever is your highest offer, he will pay you that. Simple. You say 1 crore, he'll give you 1 crore. You get out.
My Lord, then can we have Monday?
Highest offer would be that which you are willing to pay. Only that you will receive.
My Lord, then I am really obliged and indebted too, my Lord.
Tomorrow,
and can we have
Passover.
Monday, my Lord?
No, Monday. Passover.
I am honored, my Lord.
Have you understood?
Monday, my Lord.
Have you? No, not.
Well, I understood that whatever the offer he is given, that whatever the highest offer he will be there, I'll pay. That because whatever the highest offer he will pay to me.
Whatever highest you will offer to him.
He will pay to me.
Yes.
He will pay to me.
And it will be vice versa also.
That's fair, my Lord. I am really indebted. I am honored to my Lord.
Passover. Go out and talk.
My Lord, they are in Bihar. That's why I
know that they are available.
My Lord knows more about Bihar than both of us.
You talk.
No, we are there.
You go and talk to them on mobile.
Item 19.
Lord, okay, let's have tomorrow, my Lord, because let me interaction in every respect.
Tomorrow.
I am honored, my Lord.
Tomorrow we are, gentlemen, we are very clear. We are dismissing the matter. Only for settlement, we are adjourning it.
I know, my Lord.
So you say that you will pay 1 rupee. He will give you 1 rupee.
That's right, my Lord.
Ah.
That's fair, my Lord. That's a fair one, my Lord. I am really indebted to my Lord.
If you say 1 rupee you are ready to give, then he will no difficulty.
That's right. And if I say 1 crore, he let him give him the 1 crore.
But then you have to pay 1 crore to him also.
I had to either he accept or either
exactly.
That's fair, my Lord. Fair enough, my Lord. Let us see, my Lord.
May it please the Lordship. My Lordship.
Yes, ma'am.
The entire litigation emanates from Plaint, which is based on
72. September 2022 is the date which is filed. So what do we do now?
SLP is to be dismissed prior to the beginning of Order 7, Rule 11. Your Lordship will kindly see the Your Lordship.
Thank you for your interjection and intervention.
Your Lordships, this entire litigation emanates from a falsity in the plaint. If your Lordship will...
The falsity of plaint is not what 711 has to be seen.
No. It has to be seen for the reason that on the basis of that falsity, the entire litigation has continued. I have not delayed the proceedings.
Concurrently, 711 dismissed. Therefore, you tell us
711 is based on a document which is their own document attached to the plaint.
We only, for 7-Eleven, we only have to see.
Yes, yes,
content of the plaint.
the cause of action, your lordships may see para 11 and 12 of the plaint. Your lordship,
Thank you.
your lordship will just bear with me for a few minutes.
That page 47 to 72 is the plaint. Read that.
That page 47, page 54, para 11, your lordship may see.
We have seen that.
They say the cause of action emanated from Delhi, but because goods were dispatched from Delhi. On the contrary, they annexed along with that in para 12 documents showing, they themselves show that it has been dispatched from Faridabad and it has been dispatched from Nagaur in Rajasthan. These two things.
Page 54, we'll read it for you loud. Thank you. Thank you, ma'am.
Item 20.
Your lordships may then direct your lordships that the bank certificate that they have produced and on the basis of which the entire 7-Eleven has been dismissed, that has not been taken on record. That is not a document on record, your lordship. Till date.
No, we will only say that it will be open for the parties to place on record for the trial. Trial is expedited.
It is on the fast track. There's no need for that actually, your lordships.
Leave it then.
But the bank certificate should be exhibited.
We can't say why.
Evidence, which of course trial is going to be left open. The admissibility of that bank evidence should be left open. We will challenge it.
All contentions are left open.
Item 20.
As a correct, the observations made in the tuned order shall not shall not come in the way, shall not be construed as an expression on merits, and the trial court shall decide the issue independently.
The trial court, your lordship, yes, because including the issue of jurisdiction, your lordship.
That is
All issues.
All much of the issue.
Which is already.
That will suffice, your lordship.
All issues.
We'll need evidence from it.
Item 20.
Item 20 minutes. I appeal for the petitioners, my lords. My lords, may kindly see page 39, my lords. 39, my lords, is the provision, my lords. Subsection 8 of section 21 of the Act, my lord. May I read, my lords? Clause 8, nothing in clause A of subsection 1 shall apply to a building without, well, at page 39, my lords. Subclause 8.
Page 39.
Page 39, my lords. Subclause 8, my lords. If I may read, my lord. Nothing in clause A, my lords, of subsection 1 shall apply to a building let out to the state government or a local authority or to a public sector corporation or to a recognized educational institution unless the prescribed authority is satisfied that the landlord is a person to whom clause 2 or clause 4 of the explanation to subsection 1 is applicable, provided, my lord, this is, my lord, the provision which I am referring to, provided that in the case of such a building, the district magistrate may, on the application of the landlord, enhance the monthly rent payable therefore to a sum equivalent to 1/12 of the 10% of the market value of the building under tenancy, and the rent so enhanced shall be payable from the commencement of the month of tenancy following the date of application. Now, let's kindly see, my lords, in 1999, he files an application for the enhancement. My lord, admittedly, my lord, state government is the tenant, they are the landlord, my lords. 1999, my lords, he files an application which was ultimately decided in 2014. Rate at the rate of 14,004 rupees 4 per square feet was fixed. But the appellate authority sets aside the order and remanded the matter back to the High Court, back to the prescribed authority. Now, my lords, they went then before the High Court, my lord, and filed a petition under 327. Now, my lords, may kindly see how the High Court has dealt with this, my lords. Page, my lords, 2, my lords. Kindly see page 2, my lord. Para 4. The contention of the counsel for the petitioners is that the respondents have taken the adjacent premises on rent and are paying rent at the rate of 14 per square foot, and the petitioners would be satisfied if the rent of the rent of the rate is fixed at 14 rupees per square foot. The said assertion has been made specifically in para 18 to which no reply has been given. Remanding the matter at this stage will entail further delay. As such, accepting the rates as fixed by the respondent for the adjacent premises to be fair rent, both the orders are modified. Now let's this 14, the rate of 14 rupees was neither pleaded by them. It was not in the writ petition, my lord. Kindly see para 18, my lordship. High Court says para 18 they have pleaded. Page 91, my lord, is the relevant portion of the writ petition, my lord, which the writ petition, my lord, starts from page 87, my lord. The para 18, my lord, which the High Court refers and says that the state is paying the rent at the rate of 14 rupees per square feet, my lord. Page 18, my lord. There is no such averment, my lord. Page 91, my lord. Para 18, bottom.
Para 18?
1-8, my lord.
Fifth line?
Page 91.
Fifth line from bottom?
My lord,
Fifth line from bottom, what is this?
yes, my lord. But not at the rate of 14, my lords. This is at the rate of rupees 5.
Right.
And that is also, my lords, in a building which is away 2 kilometers away, my lords, situated in a different locality. This building and that building, my lord, they can't be.
Madam, kindly see your lordship's order dated 19th of December. Your lordship, kindly see that order. That your lordship had issued notice only to see about this provision, my lords. May kindly see the order dated 19th.
The issue which arises for consideration is to whether with the omission of clauses 2 and 4 contained in subsection 1 of section 21, the
proviso contained section 8 would be operative and continue to govern the premises.
Yeah.
Now, if your lordship may kindly see the supplementary counter affidavit filed by
yes.
And your lordship may kindly come to page 2, my lords, paragraph 2.
Yes.
Now, if your lordship may kindly see section 21 at the bottom, my lord. This is saying proceeding for release of building under occupation, my lord, my lord, may kindly turn over, kindly come to page 4, my lords. What fell from my lords was page 4, my lords. Explanation. I'm so sorry. Page 4, my lords, what is explanation? Not Roman 2 is this, my lord, which has been omitted later on, my lord. But what does it say? It says where the landlord was engaged in any profession, trade, calling, or employment away from the city, municipality, notified area, or town area within which the building is situated, and by reason of the cessation of such engagement, he needs the building for occupation by himself for residential purposes. So, this is, my lord, in case when it is the application has been filed for bona fide requirement. Similarly, your lord, for bona fide requirement. Similarly, your lordship may come to Roman 4, my lord, at the bottom of the page. The fact that the building under tenancy is a part of a building, the remaining part whereof is in the occupation of the landlord for residential purposes, shall be conclusive.
Only for bona fide requirement.
So both is for bona fide requirement. Now, your lordship may kindly see 21(8), my lords. May kindly see, my lords. Page 10, my lord. Page 10. So your lordship wanted to examine this now. If your lordship may kindly come to page 10.
Nothing in clause 1.
Nothing in clause A of subsection 1 shall apply to a building that out to the state government or to local authority or to a public sector or to a recognized institution unless the prescribed is satisfied that the landlord is a person to whom clause 2 or 4 of the explanation is applicable. So clause 2 and 4 talks about bona fide requirements. So it is only confined to that. Now see the proviso, my lord. So under this act, my lord, except this proviso, there is no other provision where I can move an application for enhancement of rent. Now, my lord, I'll read this, my lord. Provided that in the case of such a building, the district magistrate may, on the application of the landlord, enhance the monthly rent payable, therefore, to a sum equivalent to 1 rent. So this is the application, my lord, which was moved by me from 1966 till 2000.
No, your petition is for bona fide requirement.
No, my petition is for enhancement of rent.
It is not for bona fide.
No, it is not, my lord. It is for enhancement of rent.
See, 1 minute.
Please, my lord.
Proviso doesn't give you power. Proviso is only a residuary clause. No? It is not a substantive.
No, in this case, madam, that's what.
One.
Please, madam.
The question of interpretation of statute.
Please.
There is no provision in the statute other than this proviso, whereby you can seek enhancement of rent.
Please, madam.
Correct?
Please, I'm grateful, madam.
This is what you are saying.
Please, madam.
Our immediate response to this is
Please, madam.
that 21A deals with bona fide requirements.
Please, madam. Please, madam. So
21A says nothing in subclause A in subsection 1 shall apply to building letter to the state government.
So it's a bar.
There's a bar.
Yes.
Provided that in case of such a building, the district magistrate from the application enhance the monthly rent payable to some equivalent to 112 and the rent so enhanced shall be so and so. Provided further that a similar application further enhancement. Now, this is a case where there is a petition for bona fide requirement.
No, madam.
Exactly, because
the application, may I see the application itself is for enhancement of rent only. It is never for.
What we are saying is that the section applies only, subsection 8 applies. Section 21 deals with what?
21 deals, yes.
With what?
Deals with, the kindly come to page 6, my lord. Page 6.
21 deals with proceedings for release
of building under occupation of tenant. Please, my lord.
Correct.
Please, my lord.
So these are the grounds on which you can seek a judgment.
Please, my lord.
Section 21 only deals with that.
Please, my lord.
And section 21, subsection 8 carves out an exception that
state government is barred. We is given.
Exactly.
Please, my lord.
Also, it also says that in any case there cannot be any enhancement of rent, but nonetheless, there is a second proviso which qualifies the first proviso that in some cases the collector may do so.
So
now your petition is not for enhancement of for bona fide requirement.
Please, my lord.
Your petition is only for enhancement of rent.
Please.
What we are saying is there has to be an independent provision in the statute seeking enhancement of rent. If there is no such provision, then you are bound by the statute.
My lords, on proviso, if your option permit, I have some judgment, my lords, in my.
Let's see.
Please, please, my lord.
Let's see whether the proviso can be substantive.
Please, I'm so grateful. I'm so grateful, my lords.
Yeah. Because this proviso is applicable only.
May I just. May there's short note, madam, and I'll show the judgment also. May I read the now, my lords, may kindly see this judgment, my lords.
No, where is the judgment?
I just give the citation. Now, I will only see this judgment, my lords. 1985, 1 SCC, page 591. (1985) 1 SCC, page 591.
No, that is on the proviso.
I'm proviso. When proviso will what I'm trying to submit for my lord.
I know we deal with the reserve condition. Parties may file their written submissions.
Within 2 weeks, madam.
We have heard and counsel for the parties, as also Ignara. Peruse the statute as filed by the respondent. With a supplementary counter affidavit dated so and so. Written submissions be filed.
And I will also take note of this now because I have all the judgments I use. I'll do. 2 weeks time may be given, madam.
In 10 days. 2 weeks.
Next week I'm
15 days.
I'm so grateful.
Lordships have stayed the proceeding. I am depositing the rent as fixed by the.
We are saying file your submissions.
Yes, yes, I'm grateful.
Grateful.
Please, minutes. 21 comes up after notice minutes. Pleadings are complete minutes. Counters been filed minutes. We have also filed a rejoinder.
Yes.
Minutes. The petitioners here minutes are the petitioner 1 is 70 years old and the petitioner 2 is also 65 plus minutes. Now, my lords, for a transaction of the year 85 and 89, my lords, an FIR is sought to be registered now, my lords, after
Are asking of the High Court?
Yes, my lords. Now, my lords, power of attorney was executed in the year 1985, my lords. Clearly, my lords, which is a registered document, my lords. Now, my lords, he's gone back after 37, 40 years to say that no, I never issued such a power of attorney. Now, my lords, the property is in my hands. Thereafter, it has changed hands because I have subsequently sold. For all these years, my lords, he doesn't wake up. And 2022, my lords, suddenly he comes up and gives a complaint to the police saying that there is a forgery, my lords. Now, my lords, after that 2022 complaint to the police, my lords, police carry out an investigation. An inquiry is carried out. Clearly, my lords, the police find that this is a civil nature dispute, that parties were known to each other. There was a clear registered power of attorney executed, on basis of which the sale deeds are executed. And my lords, therefore, the police finds that this is a civil dispute and civil court should have been.
What do you say?
Lord, I am the respondent number 1 here in complaint. There is a power of attorney.
How do you justify passing this?
I'll justify that.
I mean, there is no reason apart from the.
High Court, my lord, only says, my lord, comply the magistrate. The order is by learned magistrate, which is my lord, which is, my lord, at page 56. It is a 156 complaint. Yes.
58.
Yes. So, despite that also, they don't register an FIR. Thereafter, I'm forced
Is this the manner in which the High Court will say register an FIR?
Not, but there is no option, Lord, if the police is not registering.
Why?
Not all magistrate says is, all that magistrate says is investigate and lodge an FIR. They don't do it another for 10 days. Earlier also, my lord, for 2 years, they keep my complaint without doing anything, without acting on it. Just, my lord, I'll show how, my lord, the police have colluded with them. Kindly see, my lords.
No. Police filed a closure report.
I'm on that only. I'm coming to that only, my lords.
Listen to us.
Yes, my lords.
Police filed, the closure report is at page 52.
It was not filed. That is what I'm trying to say. It was not filed anywhere. It's a, my lord, it's a created document. Just see, my lords. My complaint was 14/3/2025, which is at page 50, 156 complaint. At page 50, my lord, is the date, 14/3/2025. Notice gets issued for 8/4. My lord, now see page, the closure report, which is at 51, and see page 55. 1 day before the date of hearing before the learned magistrate, they create this document on date is not 7/4/25.
The police has filed their reply. I'm sorry, they have filed their reply. Police says that
not filed anywhere, my lord. This is only culled out from their
Page
file.
52, you yourself say that the document is of the year 1984, 85.
My lord, the document I say has
When did this forgery was committed in the year 84, 85?
was not known to me, my lord. It's a power of attorney registered, my lord. Kindly see, my lord. There I'll answer, my lords. The property, 1 second, my lord. Just clarifying that, my lord. Property is registered in Chengalpet, my lord. This power of attorney is registered in a jurisdiction where neither he lives, nor I live, nor the property is situated.
We have not to go into that.
Need not have.
We are only asking you one thing.
Yes, my lords.
The alleged forgery was committed in the is in relation to a document of the year 1983-84.
Precisely.
Correct?
Yes.
And that document has been acted upon immediately, multiple times.
No, my lord. Acted upon, what he does is, he sells it to his own wife.
Whatever it be, it was acted upon.
But I, my lord, discover the forgery when I went to construct my lord, a commercial building. I was not, my lord, one aspect, lord. If the lord, if the power of attorney is registered with the registrar where the property is situated, my lord, encumbrance certificate will reveal a power of attorney or any other document. It is registered in a third jurisdiction of which, my lord, none of us had any connection. How would I, my lord,
we tell you, page 52, read your complaint.
But
this you say that you got to know about this act of forgery only.
Yes, in my complaint I say.
We will tell you. The counter petitioner originally claimed that he was in the possession of the other document, the land in dispute, and the petitioner, after the registration of the power of attorney in his favor, and said it is none. He also said the petitioner handed over the possession of the land so and so, and he served for them for 15 years and subsequently died of staying by it. The counter petitioner also said that the land is in possession over since so and so, so and so, so and so. The petitioner, after about 40 years, claim over the property, questioning the genuinity of the power of attorney document, registered in the counter petition's validity, and so and so, so and so. The question as to why he had neither moved the civil court or approached the police in the eye of counter petitioners taking possession of the land or registering document in favor of the petitioner for nearly 40 years is unanswered. It appears that the petitioner for some reason is endeavoring to register a criminal complaint so and so and so. During the inquiry, it has come to light that disputed land was taken into possession by the counter petitioner Ravi Kumar in 85 and he's been in continuous possession since then. It has been handed over possession so and so, so and so. If the petitioner so and so decides to contend over the genuinity of the attorney registered by him as so and so in favor of the counter petitioner, and there has endeavors to make all transactions subsequently invalid, he can work out his remedy through a civil court. If he intends to take back the possession of the said land, they can be achieved through civil court. And the petitioner enters the said disputed land forcibly, it amounts to criminal trespass. He moreover has no locus standi to disturb the possession of the present owner of the so and so, so and so. In view of the same, the is closed.
Lords, may I just answer this? These my lords are reading a document which is not available in any record. Kindly see, my lord. That's why I wanted to point out at page 55. On 7/4, this document is created. There is no such closure report in any record available. 7/4, date of hearing, next page 56, is my lord 8/4. They don't reveal before the magistrate also. Same person, Deputy Superintendent of Police, he is respondent number 2 in my petition, doesn't reveal to the magistrate that there is a closure report. This was created document. I was never given a notice, my lord, when, my lord, kindly see, my lord, the procedure is, when you, my lord, when you seek to close a complaint, the complainant is notified. Where is such notice given? No such, only the accused knows. How come that accused gets this document? This is not produced before the magistrate. That's a totally created document. My lord, might have been authored by the petitioner.
But the High Court should have given reasons why the FIR be registered.
No, that is, my lord, High Court merely
High Court
says,
cannot say.
no, High Court says comply with the magistrate's order. It is the magistrate's order. Kindly see the magistrate's order.
That's not what the High Court says.
No, no, my lord. High Court, my lord, when magistrate says investigate and lodge an FIR at page 58.
You are,
my lord, thereafter also, my lord, the police does not take any action. Then I am forced to go to the High Court. High Court merely says what the magistrate has done. And he is aware of the magistrate's proceeding. He doesn't challenge the magistrate's order.
I'm
Lord,
not heard.
Challenge the 156
I'm not
order.
even heard by the magistrate.
Please let me.
He's not even made me a party in the High Court.
My lord, he was given notice. He was given notice pursuant to this order. My lord, he was all along aware.
We will set aside the magistrate order, as also the High Court asked the magistrate to pass a fresh order after hearing.
My lord, Lordship may do that. Lordship may do that. Lordship may do that.
Please.
Having heard
Lord, expeditiously. Lord, one aspect which I wish to, Lord, in their counter now, which now they have filed, they have found all the power of attorney, subsequent document are all fraudulent.
Whatever it is, we are having heard learned conservative party, we have the conservative view that justice would be best met, more so when prior to passing of the impugned orders, the present petitioner was never heard. And that the order dated the magisterial order is
yes,
8/4/2025.
8/4/2025.
2025.
It's at page 56.
Page 56. As also the
High Court order is 17/4.
Order passed by the High Court. Impugned order dated since the passed by the High Court are caused to be set aside. With the matter. With the direction to the concerned judicial magistrate to take a call on the complaint filed by the instant respondent. Also, we are pained to observe that we, with anguish, we must express our anguish in the manner in which the orders are passed by the magistrate as also the High Court. Apart from not affording any opportunity to the concerned aggrieved person, the order does not assign any reason for taking a particular case.
Because there is a subsequent FIR registered, that may also have to go.
May I just say only one thing?
Look at the way the magistrate is passing the order.
Under the earlier regime, my lord, accused cannot be made party because now under the new act, they are entitled for notice. In view of the lordship may not say this, Lordship may say, in view of the new act, may not accuse.
Yeah, he had said, not only because not the same reason, not afforded opportunity. High Court should have afforded opportunity, but that apart, no reason is there.
Look, magistrate cannot give reason at this stage. You can only say investigate and register.
Ramapsha, he has to say that I am convinced.
Not in that. Not that, my lord, will leave nothing for the investigating authorities.
The FIR dated page 76. Consequently, FIR dated so and so page 76.
18.4
is 18.425 is quashed and set aside. So party shall appeal before the magistrate on dash.
The magistrate may then hear us and then
who shall pass an order fresh on the respondent's complaint.
I'm so obliged, grateful.
Matter is already fixed for the 4 p.m. lot. Matter is already fixed for the 4 p.m. lot and jointly application is already.
No, application is there now.
Yes, my lord, and both parties are on the way, my lord. They are coming here.
Possible.
Please, my lord. Obliged.
Please, my lords. My lords, the matter has been settled amicably, my lords. I'm seeking 1 week's time to place on the court.
Lordship said pass the detailed order last week. Settle. We have signed the settlement deed, sent to them.
We are yet to receive the settlement deed, my lords, from the petitioner, my lords.
Why should you take unnecessarily time?
My lords, she lives in Kolkata, my lords. We signed the respondent signed the papers on the 3rd day, my lords.
That is adjourned. Please don't. एक हफ्ते के बाद लेट.
Grateful, my lords.
My lords, the mediation is still going on.
Mediation is stated to be in progress.
Item 25.
That's okay.
My lord. Mediation succeeded, my lord.
Sorry?
Mediation succeeded, my lord. We settle now. The dispute settled amicably.
142 application.
We need to file because you have not received the certified copy of the mediation.
As per the report of the learned mediator, parties have amicably resolved their dispute. Parties undertake to file a joint application in Article 142 of the Constitution of India.
In terms of the.
Within a period of
3 weeks.
2 weeks. One week only.
We need to bring in demand draft also there, my lord.
Demand draft you incorporate, will pass the order.
After 2 weeks, my lord. Just after 2 weeks.
2 weeks.
Item 26.
Please, Lordship. Lordship, as per the last order, they have to comply the order, Lordship. Yesterday late night, they served the copy, Lordship, of the affidavit. But that affidavit also not disclose the payments, Lordship.
Who's for the respondent?
There was a direction.
Who's for the respondent?
Appear to in person also, Lordship.
Possible.
As I appear in 27.1, your lordship said in a different combination earlier released it from part heard. Now it has got listed before your lordships. And the issue involved will wrap up in about half an hour.
You're in 27.
Malad, that's me. 27.1 is me.
No, 27.
27 minus. Malad, the issue is the same.
Same issue. Same order.
This side would take about
half an hour, 40 minutes, my lord.
So 1 hour on this side. This side would take how much time? So we are only wondering, we'll tell you. See, this is not a regular bench. Honorable Justice Massi is sitting with me. After the CV, which is likely to be over in April, he's going to come back. So whether we should hear it or not is what we were only contemplating.
I don't want to get into the merits. My only concern is that I had the single judge's order in my favor. And since then, the entire amount I charge has been frozen since 2016. And we are in 11 years there later. Yes, so my lords, I think it can be done. If this combination can hear and dispose of this matter, maybe next week.
How much time will it take?
Lordship, actually, state has to answer the questions mainly. We are for the municipal corporation, we have to follow.
Who's for the state?
It's Swati. Well, I'm appearing on behalf of Swati Gildia. So it's just that the bylaws have been enacted.
What we do is, we just pass over. He has already indicated 1 hour. You tell us how much time it will take, then we'll fix our schedule.
Budget I am for the Ahmedabad Municipal Corporation. We have received a final copy of the parking policy drafted by the AMC.
We are only saying how much. We'll give you time. How much time you will take to argue is what we are asking. So whether we should have it in April or in May is our concern.
Malad, as per states, we have already.
We are just passing it over.
It will not take much time. That's what my.
Ask Mr. Riyal to be here, please. Thank
Okay,
you.
ma'am.
In fact, Lordship, written submission already is completed.
Maharaj, my
Gentlemen, we are in a different, we have not read our files. What are you saying?
Maharaj, my only request is if I'm not there and your lordships are fixing a date, just keep into account. Yes, my lord.
You know that it will take you this side.
Yes, my lord, I'll wrap it up in half an hour, 40 minutes.
Know how much time they will take.
Yes, my lord, I get it, your lordships, whenever your lordships feels, given that time frame, your lordships will fix a date.
If the lordship can fix it for another day, the main council is.
We'll not take it up today, but we want to know whether this combination should help the other combination. The other combination is also there available on Monday and Friday, is what we want to know.
Maharaj, it is not for me to say, but this combination can definitely wrap it up, my lords, next week or next to next. I have nothing more to say on that.
Yeah. Anyhow, we'll have it. We wanted to know how much time it should take. That's all. And you are for municipal corporation.
Yes.
Okay, you do one. Let the respondents file supplementary documents, additional documents, where we have supplementary affidavit within next 2 working days. They are with you now. We would also request learned counsel of the parties to positively file their written submissions within 1 week from today. List on ma'am को Tuesday, Wednesday day.
Very
1 hour here, 1 hour maximum there.
Great.
Any Wednesday.
This side, my lord, April, May. Great.
But in this case, the respondents have filed their written submissions only on 13th. I have not received a copy of it.
The only issue is the custom approval or not.
In fact, that is.
How do you make a ghar jamai?
In fact, that is not even the issue, Lordship, because
That's the only issue.
Because the custom is very much there. The issue is whether they are able to avail of the exception of Ghar Damad or not.
So therefore, we decided.
Yes. In fact, Your Lordship, if the lower court record can be called for, because the depositions will have to be looked at, Your Lordship, because on the question of whether Ghar Damad comes, they are entitled to the exception of Ghar Damad under the customary law.
See, kindly come to page 72. The issue is framed. Page 89, the finding is son-in-law has been adopted. That's what we don't need the trial court. We only have to go by the finding.
Anyways, Your Lordship, I have not received a copy of the written submissions. That no reason.
The written submissions is for us. You argue. We have heard the matter. Otherwise, we will reserve judgment.
No, Your Lordship, it requires to be argued.
Argue. Kindly come to page 2. The High Court and Para 10 says the instant appeal was remitted to be heard on the following substantial.
I'll just place, Your Lordship. First, Your Lordship will come to Para 12 and 13.
Para 10 first read that the substantial question. And mind you, concurrently you have lost in all the 3 courts.
Yes.
Concurrently. So Para 10, the instant appeal which is admitted to be heard on the following substantial question of law. Whether uncle-in-law is entitled under the customary law against the Osgan community to keep a ghar damad. That's it. This is the question.
Yes, Lordship, I will require some time, Your Lordship, to place my case. If it can come up next week, Your Lordship, I will just.
in my counter affidavit, Lordship, I mentioned that in the absence of the elder Karta, the next present can.
Hold for some time. This as item number 1.
On a non-miscellaneous day, Your Lordship, because I will take at least 45 minutes. Your Lordship. Non-miscellaneous.
Witness day.
On item 29, may I request for a passover?
Sorry?
May I request for a passover in this?
29 passover.
The passover.
Wait, please, my lord. My lords, the mediation is still going on. The next date is on 19th.
Mediation is in progress.
My lordship, I have a humble request that kindly tell the petitioner to give some amount to the respondent for commutation and accommodation.
My lords, I have a small grievance, my lords. On the Feb, my lords, the matter was listed. We booked the ticket. On March 10th, we booked the ticket.
Mediation is in progress.
Item 31. My lords, I'm just praying, my lords, may direct her to my lords appear physically.
She met an accident. She has provided all the medical documents that she has met an accident. That's why she has not appeared physically. On video conferencing, she has appeared. She is coming on 19th positively.
Next.
Much obliged.
Item 31.
Item 31, Your Lordship, I have received the instructions from the Supreme Court Legal Services Committee to appear for respondent number 3, 4, and 5.
Your Lordship, it seems there's some confusion because I also received and I filed wakalat for all the respondents. So, both from the legal services. My name was mentioned in Your Lordship's last order. Your Lordship had directed.
My Lord, sir, appointed Michael also. I'm here.
Miss Neha Rathi, we have appointed her.
Your Lordship, I will withdraw. Since I have received the instructions from the Legal Services Committee, Your Lordship, and before my lords.
In view of our order dated 19th of March 26, we request Ms. Neha Rathi to continue.
To appear on behalf of all the
To appear on behalf of respondents 1, 3, 4, and 5. 1 to 5.
I will withdraw from the. I will.
1, 3, 4, and 5.
Your Lordship, 2 also, Your Lordship had asked me to inquire from him. I had done that. Wakalat was filed day before yesterday. That was
Respondent 1 to 5.
I seek, Micus has filed his report. I also seek 2 weeks time to file my counter because I've recently only been able to get in touch with
Counter 2 weeks, 1 week.
Lordship, we are also seeking direction to file some additional document to prove there's no rental deposit.
We have said counter 2 weeks to join 1 week. That we file.
Lordship, just record that I will be withdrawing from this because since.
We do not know. You can write to them. I will have an order. The letter has been circulated in 32. Letter.
Hey, please continue.
Yes, please.
The respondent, Mr. Yogi.
So, Lordship, we seek.
Counter has already been.
Counter is not there.
Respondent number 2 to 5 is admin.
What is the, your application?
Pillar has been allowed, my lord.
711 has been allowed.
Yes, ma'am. No, 711, my lord, which has been moved by them, that has been allowed by the trial court. And the first appellate court reversed it, my lord. The High Court again, my lord, it set aside and they restored the trial court. But it is a question of facts and law, my lord, on the limitation, my lord. So therefore, this court says, my lord, it is a matter of trial. So it has to be seen in the during the course of the trial. I am the plaintiff, my lord.
Let's see your claim.
Please, my lord. Page number 29, my lord.
Legal aid matter. So page 33, all the actions. When was the plaint presented? 2011, na?
Please, my lord.
Union cause of action, you say that the cause of action arose in the year 2003 and also subsequent dates from 1992 onwards.
But because of it was only with respect to item number 23, Miller. They are raising rejudicata regarding that 23rd item, that was a response number 9, which has been done, Miller.
Look at your plaint.
Yes, Miller.
Your plaint.
Yes, Miller.
Your plaint says that the cause of action arose in the year 2003.
Please, Miller.
And also subsequent dates from 1992 onwards.
Yes, Miller.
Now, which are those subsequent dates you don't say? But your first cause of action arose in the year 1992 and lastly in the year 2003. And the plaint is presented in the year 2011.
That was copy of the plaint, Miller. The date, Miller, it is not there, Miller, in this.
No, it is there. We'll tell you. Kindly come to page 29. It's a suit of 59 of 2011.
11.
I will find it out, Miller.
So we are telling you.
Because of there is page number 34, Miller. There is no date is not there. Page 34, Miller.
Okay, we'll see it from another angle. Can you see page 42 WS of 2011?
42, Miller.
42 WS is of 2011.
Yes, Miller.
So suit is filed in the year
2011. It is 27 July 2011, Miller.
Correct.
Yes, Miller.
So therefore, suit is presented in the year 2011. You also know what we are saying. Thank you. Dismiss.
No, Miller. Lordship, me kindly give Miller for a minute, Miller. But I want to show it, Miller. I want to show it from my first applied court judgment, Miller.
Gentlemen, we have to see the plaint only, na?
Yes, Miller. Therefore, I am showing Miller. But I'll show you.
Sure.
Lordship, me kindly, Miller. By the time I will read it and I will make it. I need some time, Miller. I'll go through it, Miller, because I thought that they are seeking time for counter. So therefore, I had not gone through the entire matter. Lordship, me kindly put it for after a week, Miller. I will.
We'll rising for 5 minutes. Go through it just now.
Please.
We'll just be back in time.
Please.
Yes.
For page number 33, my lord, it's para number 11, it says that cause of action for the suit arose on 2003, my lord. So 12 years limitation is there, my lord. So I filed it in 2011, my lord. I am having still 2014, my lord.
Limitation for
Filing partition, my lord. Because of last cause of action, my lord, 2003. 12 years, my lord, it comes 2014, my lord. I filed it on 2011, my lord. So it is within time, my lord. If there is anything is there, if they are reading the plaint, so therefore this honorable court said it is a mixed question of law and fact. So therefore it has to be decided in the trial. 711 cannot be decided on the my lord, way of that budding stage, my lord. I will put the judgment, my lord. But there is a recent judgment, my lord. Well, recent judgment, my lord. Ask me kindly see there, my lord. Rejection of plaint. A plaint cannot be rejected under Order 7, Rule 11 as a time bar when the issue of limitation involves mixed question of law and fact, requiring the evidence.
The limitation and Article
65, my lord.
who's there on your behalf?
Your Lordship, the counsel for argument is not feeling well.
Sorry.
The counsel for argument is ill, Your Lordship. I've been instructed to seek time for filing counter appeal, Your Lordship.
What do you say about res judicata?
Res judicata, my lord, they are saying that only against the item number 23, my lord, not against other property, my lord. Lordship, kindly see, my lord. According to my lord, Lordship may kindly.
The earlier suit was with regard to only infant too.
Right, because there is order 7, order 7 rules, just I will show minute. Order 14, rule 2 minute, it says that adjudicator on that basis it cannot be rejected minute. Because here minute it is against only one property which is a 23, that is respond number 9, got that minute it is 90.
Asking. The earlier litigation was confined only
for particular, yes minute. Schedule of the property of the only one property minute. So therefore it says minute 14.2, it doesn't cover up everything minute. On that basis, on adjudicator minute, suit cannot be rejected minute. It cannot be a preliminary issue. Family. So when the property is there, minute, then it can be decided on merits, minute, it can be disposed of with the time limit, minute. Because I'm the. Right. I have no. We are close relatives, minute. Blood relatives. First appellate court has held each and every point it has been dealt with.
You see, still.
They can file their counter, minute. I will present the case, minute.
I was somewhere reading that the suit has been filed after 19 years. That's why we put it that.
But they have counted merit only in the year 1992 merit. Not like that merit. From the suit which has been filed on the item number 23, it has been degree.
You should be.
You are right, merit. You are right, merit.
My recollection of reading the file is that 19 years and not 12 years is what basically court's law. I'm just looking for that paragraph. Because they said that the delay is of 19 years, not 11 years.
But it is incorrect, minute. In cause of action, I have written 2003 minute. So 11 years minute. So I have to read one as a plaint only, not from the other documents minute which has.
I may be wrong there.
No, I'm not saying so.
You don't have to be. Where did I read? 19 years is what I'm looking at. Looking at the cause of action as pleaded.
Yes, ma'am.
And the provisions what you made submission now is absolutely perfect. There's no difficulty.
Please, ma'am.
Why do I carry the impression that 19 years is what the somewhere it is mentioned? The 1 minute, please.
Please, ma'am.
Page 46.
Please, madam.
Plaintiffs have suppressed the notice issued by them for partition in the year 1992.
Please, madam.
To which the respondent had replied.
Yes, madam.
Rejecting such claim. So therefore the limitation No, I'm.
With respect to the only one property, my lord.
No. The suit is of the year 1991.
Yes, my lord.
Partition, you sent a legal notice for partition, which was, was turned down by them in the year 1990.
But that is not part and parcel of the plaint, my lord. So now they are pleading something out of that plaint, my lord. That is their defense, my lord. The defense is that I have sent a legal notice. It has to be proved during the course of the trial, my lord. Because now because once I am admitting that in that plaint saying that I have sent a legal notice on 7/10/1992, I am out, my lord. But here the fact is that I never pleaded because they are saying that I suppressed it. So they have to produce the document and I have to mark it, my lord. So then only that will come during the course, my lord. Then the court can decide the issue, my lord, on merits, my lord. But only 711 counts, my lord. Lordship is it's a very limited scope, my lord. It is they can read as what is stated in the plaint, my lord. Not beyond that, my lord.
Argument is made on behalf of the petitioner. In behalf of the respondent.
Great.
Yeah, we'll have.
Other matter, my lords, that item 14 where your lordships are, the parties are here for lordships. Yeah.
No, wait.
Very good. Yeah,
wait.
that's it.
Wait.
34.
Please, your lordship, adjournment letter is circulated in this matter.
Item 34. Item 34. Letter.
May it please your lordship, adjournment letter is
Totally.
May it please your lordships. It's a suit for partition, your lordships. Please take it. It's a small.
Sir, I'm appearing for respondent number 8. Some of the counters are not available with me, my lords. Filed by respondent number 1. My lords may take it next Wednesday, my lords.
But otherwise, it's really not required. The contesting parties are already on record, I think, so their count is on record.
Respondent number 8. That is the defendant number 2 in main.
Counter within the injunction in your favor?
There's nothing in my favor, your lordship. Only order official.
No.
My lordships may have order dated, 10th February 2021. The lordship directed not to create any third party rights. Please, lordship, there's an order in my favor. Please, lordship.
July.
Lords, appearing for respondent number 1, 2, and 4, my lords, again adjourned for 2 weeks to file counter. The last opportunity may be granted, my lords.
Your lordship, it's a 21 SLP of fixed date may be given. 2 weeks is fine.
1 week, no further opportunity. Telling which allow.
2 weeks, my lords.
1 week.
Pleasure, Lord.
Please, my lords. My lords, I appear for respondent number 1. My sincere apologies, my lords. I'm requesting for a short accommodation. We've been given to understand, my lords, there is a B report which has been filed, where the co-accused, who's the main accused, the ACP, my lords. We would like to place that on record. Was unable to circulate a letter, my lords, timely.
1 week, no further time.
My lords, to make it some lengthy document.
1 week, no further time.
Very well.
Item 38.
May please, your lordships. My lord, this is a case of version and cross version, my lord. Where, my lord, one of the, my lord, co-accused, my lord, he's also suffered a serious injuries. My lord, his MLR is attached at lecture P3, your lordship. My lord, he has also received a serious injury with the sharp-edged weapon, my lord. And my lord, as far as my lord, the case is concerned, my lord, the offences in this case are punishable up
You withdrew it with permission to surrender.
my lord, in the High Court, my lord, it was withdrawn.
Then how can you come in?
My lord, in this case, my lord, these offences are punishable up to 7 years, my lord. They have not.
Dismissed as withdrawn and you are filing an SLP.
My lord, may grant me liberty to approach the my lord High Court.
Sorry.
Your Lordship, I'm seeking a short passover in this, Your Lordship. A short passover.
Wait, please, my lord. My lord, in this, my lord, in 2022, my lord, that was before filing of the charge sheet, my lord. After that charge sheet was filed against A1, my lord, I was not named in that charge sheet, my lord. To accuse.
My lord, I appear on behalf of the state, my lord.
Notice.
Lord, I'll appear in the trial court, my lord.
Interim protection.
I'm grateful, my lord. Great.
Yes, Your Lordship. Lords, when I was, my lords, in custody at Mathura, at that point in time, my lords, in the alleged incident, my lords, I am, my lords, implicated on the basis of a fourth disclosure statement of a co-accused recorded 6 months later.
Notice, will issue.
Give me 3 weeks to file my counter.
2 weeks, no further. 2 weeks, 1 week.
My lords, we have also, my lords, asked for interims, my lords.
I'm
interim.
opposing it, my lords.
Sorry.
My lords, I'm opposing any interim protection.
Yeah, my lords may give notice on interim also.
Notice on it.
This is on a medical condition of wife, my lord. She's suffering from leukemia. Critical.
1 week, 1 week.
My lords, 1 week will not be enough, my lords, because his antecedents are, my lords.
I have disclosed.
We have to verify the status.
Computer.
I have disclosed, my lord.
My lords, this leukemia, my lords, I don't want to sound
He's telling lies. You say that.
My lords, no, my lords, I don't want to straight away say he's telling lies, my lords, but I want to verify it, my lords. So 1 week may not be enough, my lords.
So all
they are coming after a delay of 128 days, my lords. They are coming after a delay of 128
1 week, 1 week.
Grateful.
My lord's a short passover.
44.
43. 43. Oh, with 10 possible. 44.
Wait, please, Your Lordship. But in custody since 15th of May 25, Your Lords. Charge sheet.
Reissue notice.
Would Your Lordships consider to have a returnable date, my lords?
Are you there for Maharashtra?
Yes, Your Lordship.
You there?
Yes, Your Lordship.
2 weeks, 1 week.
Deeply.
45.
Please, my lord.
How can we help you?
My lords, first of all, my lords, there is a delay of 4,098 days.
No problem.
My lords.
On merits?
My lords, the merits of the case are that my lords, the High Court has gone solely on the basis of the statement of the IO. It has given a.
What else is there?
My lords, the witnesses are not in support of the prosecution. Apart from that, my lords, also, my lords, the section 4, the maintainability of section 4, when there is no lawful.
You're lucky that section 5 they have let you off.
My lords, but anyways, it was a concurrent sentence.
It is. Conviction was there, na? Thank you. Thank you. Thank you.
Plus 43.
Please, Your Lordship. Lordships, they have been convicted, my lords, by trial court and the High Court, my lords, life imprisonment.
Sorry?
My lords, life imprisonment, my lords, 16 years in the prison, my lords.
Speak louder.
My lords, both the accused have been convicted, my lords, by the trial court and the High Court.
PW1 is there.
Section 376. Yes, my lords, PW1 is there, 2 is there, my lords. They have spent 14 years behind bars, my lords.
Then you file for remission.
My lords, what has happened, my lords, their previous offences, my lords, have been not calculated for the purpose of remission, my lords. If my lords, if I may request that only to the limited extent of that, my lords, notice be issued, my lords, to the state.
Sorry. Thank you.
Lords, because that remission, my lords, if I may point out from the imprisonment certificate, my lords. Like.
What happened to the other proceedings what we wanted to know?
Yes, no, those I filed the affidavits placing that on record. If I may just summate that, the sum and substance is this.
So what is the latest status?
The latest status is still pending.
They're still pending.
Still pending. We have mentioned we bought everything to.
What we want to do is, what we rather intend to do.
Because your lordship.
It's been reserved.
This combination or Honorable Justice Massey?
With, lordship had heard it on several dates with Justice Massey. I leave it.
We'll have it on a Monday or a Friday.
No, understand.
We'll have it on a Monday.
Yes.
I just wanted to mention that judgment. We understand we are not parties in that writ appeal, but we understand that the judgment is reserved
for a year. We will see. Broadly, we'll tell you what Mr. Emily wants us to do. We may have not fully agree with him. We have heard you. We have heard Mr. Roth.
Yes.
We have heard Mr. Luthra. We have heard Mr. Emily. We would have today only, in a different combination, passed appropriate orders that day. But we were more interested in the outcome of the fallout of all this. So therefore, some judgment has been reserved. How much time do you think it takes?
Well, may I just explain? The judgment was reserved almost a year ago.
But then it was.
Thereafter, it was recalled and maybe some submissions were made. Now, I understand that the Honorable Chief Justice retires on the 24th. We made a mention to his lordship a couple of times, informing him of my lord's what has fallen from your lordship. But that is the best that we can do.
Yeah.
Now, the division bench, the difficulty is this. The division bench, the lead judgment, my lords, is in the case of one GSR batch, where similar notices were quashed by the learned single judge. And that is the appeal pending before the DB. In the meanwhile, my learned friends' clients have filed 77 writ petitions.
No.
In that batch, there are 77.
What we'll do is,
before the single
on a Monday, we'll keep this on Monday.
Very
This coming Monday.
Logically.
Because on Mondays and Fridays, there is no CB.
Logically.
Yes.
So,
I leave it to you.
The regular combination would be there. So
Yeah.
that would on Monday.
I thought the state should also let your lordship know because there were FIRs which your lordship had registered, which you called for earlier. What is the status of those?
Who's for the state? Are you?
Yes.
Can you file a supplementary after this issue?
We will. Then not this Monday, Monday week.
Monday thereafter.
Monday thereafter.
Let the state respond indicating the latest status for all proceedings arising out of the subject matter in issue. It will be done within 1 week, at least next to next Monday.
Would your lordship say criminal proceedings? Because
all proceedings, including
because other proceedings we've already filed affidavits and the status with
let the press. You can say that you had mentioned to before the Honorable CJ.
that we have done. That affidavit we already filed.
All proceedings, proceedings, criminal in nature.
Just that just this caveat on our behalf, which is that we dispute that this is ultimately a civil appeal before your lordships and before NGT. Issue was EC.
We are fully aware.
So we are, my lords.
We are fully aware. We are
Your
not
lordships.
passing any order. But
Right.
we just want to know.
No, by all means, my lord. That.
So, my lords, just to be clear, just for my sake of my clarity. So there are two issues before your lord. One is, my lords, as to whether the interim order needs any variation. One. Because you know that certain amount has been deposited, a certain further amount according to us.
The state should deposit it in our.
There's no question of the state depositing because they have operated the
One is with regard to the interim amount.
Interim.
7 or 18, whatever it is.
That's correct. Now the second
issue
issue
is with regard to the final order being passed by the
Honorable NGT.
NGT.
Yeah, and the third issue is, my lords, about the expanded scope.
We are into the expanded scope
Yeah.
only today. Otherwise, we would have passed orders. There is no
No, this is
clear in our mind about that.
Now, the NGT order, my lords, there is already a final order with the earlier order partakes into the character of a
not
final.
either.
Not just
We
one.
largely.
They file an affidavit making certain allegations against me on 13th of April, I'll respond to that.
By all means, there's a lot. By all means, they should respond because they have a lot of responding to do. They are mixed up in something very serious. Mixed up in something very serious. He's a sand trader.
The private respondent shall also file.
It's interesting to hear this submission from someone who's been held by the NGT.
And from the state who is responsible for these PCs.
As virtually having, my lords, completely damaged the environment.
Oh, right. Before, my lord, this is most unfair, without explaining their own stand, why they got the ACs, how they got them, to make, it's very easy to pass the buck and distract.
And they have reaped the benefit.
Thank you, thank you.
Essentially, there was some mistake.
Yes, please.
Please, Lordship. I need some more time to Lordship. The talks are going. He's a diabetic patient, Lordship, petitioner. He's talking with the. Yes, Your Lordship.
Someone said it has failed.
We'll try, Your Lordship. Once I told my client only for mediation this has been referred. For 15,000 he's asking. I told him only for mediation purpose it has been referred. Some more time.
Statement is in progress.
July.
July.
Open.
Chief Sarmalots passed it over for us to explore if there is some possibility. Once the offer is a bridge too far, won't work out. So I don't want to say much.
So then we'll reserve them.
Let's may hear it on merits, my lords. I would like to give you the.
They have told you what facts are. You may file it.
We'll come up with a 5-pager, 1 week to file it.
See, file their written submission both on facts and law, giving the paragraphs of the judgments they seek to that.
Very deeply obliged. Grateful.
2 weeks.
Grateful. Deeply obliged. Please, I beg to appear for the petition this matter. This matter was listed at 4, it came in the cause list. That's what, in matter was listed at 4 p.m. today.
Today, 4 p.m.
Yes, ma'am, it came in the cause list actually.
And can they?
I have asked them to come as early as possible. I have told my instructing counsel also.
Why we said 4, we'll tell you.
Please, sir.
This was perhaps an order passed when the different combination was there. Honorable Justice must see.
Please.
We wanted to experiment.
Please, sir.
But this is still our mind.
Yeah.
And whether all settlement matters can be kept at 4 o'clock on a particular day, so that we can, spend more time.
Right, sir. Right.
But they have settled, so they can join digitally after lunch.
After lunch, I have told them anyway to be here makes somehow here. Because there's some exchange of drafts to be.
That's okay. We bind the party.
I'll ask them to be here after lunch.
Password 26.
Grateful.
We have filed a complaint affidavit yesterday.
Sorry?
We have filed a complaint affidavit yesterday night. It's not on a record, my lord. It's for the last instruction of this honorable court. And further, my lord, the respondent is in a medical difficulty. Also, he's appearing through virtually. So the doctor has advised him not to travel. I have a prescription right now.
That affidavit also misrepresent, Lordship. He is not pay the honor as per the orders, Lordship. I will file my affidavit disclosing the facts.
Certain affidavit stands filed by the respondent. If the petitioner responded within 2 weeks.
Password 29.
My lord, may I, my lord, my apologies. May I request that this matter be taken up on Monday?
Sorry.
Senior counsel is on his legs in another court.
You are good enough for us, sir.
My lord, this is a matter where my lord had interacted with the children. And on the last order, my lord had recorded the understanding between the parties that the children will be permitted to do video conferencing with the father on every day this last month.
I tell you, Lordship, children have been talking, I've interacted personally with the client. No issue at all with visitation rights or the father speaking to the children every day. That is not the Lordship. The custody is the issue. Trial court had denied me custody. Honorable High Court has granted me custody. In the order of 28th July, your Lordship had limited the issue to visitation rights. Now, visitation rights, I have a proposal. It is, according to me, it is according to me.
You give it to him.
I've given it already. Now, this has been going on. Not vacation. They can take half the vacation. The only condition she has is this husband is in abroad, Kuwait. Please don't take the child abroad during the visitation rights. India, wherever she wants to take, they want to do, they can. That's the only, and every day they can talk.
No, you can respond to it.
Yes,
Not,
I'll
I just
actually
say this,
respond.
why I'm saying is, this exercise of me giving it and them having to respond has happened 2 times before. Last time they came and said, order is recorded in the order. They've said that they want to argue only custody, not visitation rights. Now, so I expressed my opposition to that because Lordship had recorded in 18 November order.
We are aware.
Yes. So today, if this of me giving the same to them and them responded, the response was, we don't want this, we want to argue only custody. That is what they are saying. Now, because that, according to me, that issue is not open anymore.
Who's the senior?
Sudhanshu Chaudhary.
Mr.
Yeah, Mr. Sudhanshu Chaudhary.
Some other day.
Yes.
Was there. That has been passed over.
No, I don't want an order in absence.
Mr. Sudhanshu regularly appears.
Yes.
Only he doesn't take adjournment.
Your Lordship want end of the board, subject to your Lordships. If any other matter is there,
No problem.
wait, if she's there. Yes.
After lunch.
Obliged.
He was here in fact.
Yes, he was here, just like that. Yes, he was here. Obliged.
Possible 39.
Please, as Lordship. Lordship, 6 accused have been granted bail, Lordship. Charge sheet has been filed in this matter. Investigation is over, Lordship. My name didn't appear in the FIR.
Where is the charge sheet?
Lordship, charge sheet is not under our custody, Lordship. That is the problem, which is why we could not file it, Lordship. Because we have yet not appeared before the court. The compliances have yet not happened. However, charge
The allegation.
allegation is of 302, Lordship.
Mob lynching.
Mob, Lordship, but Lordship.
You want anticipatory bail.
Lordship, I completely agree on that point, Lordship. But what requires to be seen over here is, Lordship, there was a crowd that, as per the FIR, there was a crowd that assaulted the person. My name was nowhere taken. There is no specific allegation against me. Also, 6 people have already been granted anticipatory bail. 6 people with whom I stand on the same footing, Lordship. 6 people already granted anticipatory bail by the Sessions Court, Lordship. And my position is also on the same footing, Lordship.
Where is that, or where is that fact that a bail was granted to them?
Lordship may have annexure P2, P4, P5, P6. I stand corrected, Lordship. 5 people have been granted anticipatory bail. 1 person has been granted regular bail. Annexure P2, if Lordship will have, that shows the anticipatory bail order of the first person, the one who has been granted bail. Thereafter, if Lordship will have annexure P4, annexure P5, that is the anticipatory bail of the another person. P6 is the anticipatory bail order of the third person. P7 is the anticipatory bail order of the 5th person. So all total 5 persons.
All these persons were not named in the FIR.
Even I have not been named in the FIR, Lordship. If Lordship sees the FIR, it's a.
Are you there for the state?
My lords, I appear for the state. I would like to apprise the honorable court that warrant of arrest has been issued. He's been absconding from last 6 months now.
No, just
In
1
September-
minute. 1 minute.
Yes, my lords.
And the FIR, his name is not there, unknown persons.
FIR, there was no name. There were around 200, 250 people. Yes.
A bail has been granted to similarly situated persons. Why are you opposing his A bail today? And you will file a response, A bail.
Lordship, interim protection
A
meanwhile.
bail, that is the interpretation.
Obliged, my lords. Obliged.
Nate, please. Though it looks, this is nothing. The Lordship's order 6 Rule 17 application gets moved, my lords, in a suit of 21 in 25 for the amendment. What has happened, my lords? I am the defendant. I say that the land belongs to me since 1981. Now, my lords, in December 24.
Yes, it says
Yes, my lords. In December 24, my lords, in 3912, he says the High Court directs, my lords, that the matter to be disposed of within a period of 1 year from the day, my lords. That is December 24. In September 25, my lords, he now moves an application under Order 6 Rule 17, my lords, for the amendment. And he says it will not change the nature of the suit. My lords, it's not about only that.
He's purposely, my lords, trying to delay the entire process.
Is it necessary for determining the controversy in issue or not?
My lords,
That's what we have to see.
yes, my lords. Now, my lords, he from day one.
He may be procrastinating.
Yes.
He knows he'll lose.
My lords.
He has a right to move an application.
That the problem is your lordships have also seen whether it is getting, if any party is getting.
What we have to see is whether amendment is necessary or not.
Whether it will also cause injustice, your lordships also have said so, my lords. Now this person, my lords, he knows that now because he has got a status quo order. So therefore he is trying to delay the matter, my lords, purposely. This is the one problem today, my lords. If your lordship, my respectful submission is that if he says that no, at page 4 of the impugned order, if his contention that the evidences will not be reopened, and if your lordship may request the court to dispose of the suit, I will not get into this aspect, but this is unfair to me because he's purposely doing it. December he gets an order. He himself says that I have no problem if the suit is disposed of within a period of 1 year. In September 25, he moves on one application. So his intent is something else, my lords. My only request is if the evidence will not be reopened, my lords, as he himself has said, and if your lordships can, my lords, direct the trial court to dispose it of the suit because his evidence is already closed. I have a title, my lord, sale deed since 1981. There is no dispute about it. And that was the reason why 3912 was rejected by the trial court, appellate court, high court granted status to lords.
It's like
Sir, I serve for second. 1 week? Within a week, please.
Notice the state. Yeah. Notice to number 1 and 2 only.
Lordship.
Huh?
Plus 1 is the plaintiff, second is the state, my lords. Third is
no, sorry, 1 and 3.
Plus, in fact, 3 is defendant number 2, so he has to be with me. It's only for plaintiff contesting respondent number 1. He is the only person needed.
Notice confined only to number 3. The number 2 state to yahi hoti hai.
Yes, Milos 1 only. Only 2, 1 and 2. State I will serve, Milos. Yes, I will serve this. Lordship. Yes, Milos. I have been a counsel for the state, Milos.
Notice confined to 1 and 2. But respondent number 3 is the defendant in the original plaint. The amendment is sought only, amendment was sought, plaint is sought only by the plaintiff, respondent number 1. Notes for the dusty to date is. Which only get.
Please, my lords, I'm seeking a short passover. Senior counsel Mr. Huda is on his legs. It may be taken at 2 o'clock.
2 o'clock?
Wait, please. I have received a message from Nikhil Goyal saying that his uncle has passed away and he had to go. So I must bring it to your lordship's notice.
I deputate the state of Haryana. We are being led by Mr. Nikhil Goyal in the matter.
Which case? Which case?
Well, it's item number 101.
He's for these are those constables, Lord HSISF, which your lordship said. Actually, I had to recapitulate and close it today. So
and we'll have to have some.
I can't once he sent me such a message, Lord, I have to.
No problem.
Tomorrow, then, Lord, if he is coming to court tomorrow, we can do it tomorrow.
To take his
No, we'll give a week's time. And after all, some death has taken place. We don't know whether there or not.
Yes. Then next, because only
Your lordship's combination will be there next week because CB is not finishing.
CB is going to be there at least 4 months.
All right, so it will retain its position because it was part 101 next week.
Next week.
Grateful, my lord.
Yes.
Item 102.
Your lordships, I appear for appellant in 102, my lords. The dispute is settled.
102. 102.
Indeed, my lords. The mediator has sent a report, my lords.
Responding number 2 to 4, my lords. As per instructions, the matter has been settled.
Matter has been
Settled, my lords.
The mediator, the report.
Indeed, my lords.
Office report. Agreement is also.
My lord must have received the mediator's report.
You should receive, I think.
Member of agreement.
Along with the.
Balaji Mandir.
Indeed, my lords.
So then we'll modify the new judgment in terms of the report to be done here.
My lords,
Yes, my lord.
Huh?
my lords,
Yes,
please.
Who's for the?
I am appearing for appellant, my lords. Chinmay
I am
Deshpande.
appearing for respondent number 1, my lord.
We have perused the report of the learning mediator. The parties have entered into settlement in the following terms. Just the pura extract. The parties undertake to abide by the same may be made aware of the breach of consequences of the usual order. Improved judgment is modified.
Placement.
Thank you. Word of appreciation.
We request the report be extracted in the order, my lords.
It is there. Word of appreciation for the mediator as also the nonetheless.
Highly obliged, my
Grateful,
lords.
my lord. Grateful.
We'll continue. We are rising now. There's another maybe a different combination just now, and then we'll.
My lord,
At 2 o'clock, we'll continue with the.
my lord, I had requested, my lord, my senior is not available, my lord, for 102 to 103 to 107, my lord.
We'll wait for
All right.
2 o'clock.
As well. We had
2 o'clock, please. Thank you. We'll just be back.
check. We'll take objection to.
Some MA is there.
Mr. Partition also is there online.
Para 59 is reproduced in there.
We have not received any statement.
Your Lordship, there is a status which office filed. Yes,
We have filed a contempt application that should also be listed.
It may not be on record, Your Lordship.
Our office report says that it is further submitted pursuant to the order. No status report has been filed thus far.
Since filed. Filed, it's been filed, since filed.
1 minute. And lastly submitted that so and so have been filed and the matter content of the MA is filed. What is the MA?
Page 18.
MA they have filed, my lord.
Your Lordship,
they want the state possibly wants an extension.
No, we don't, Manoj. From 2000 and registry has recorded. Registry has recorded, Manoj. We have complied because when it went to the committee said you pay those who are entitled to between 2016 and 2019, for whom you have the records, pay immediately. We have paid. We paid the 6,000 crores. For the balance, they say you find out what the facts are and then come back to us and then we'll decide as to how that is to be paid. So we have complied and we're interacting with the committee. That's what it is.
Your Lordship,
We have a contempt application, but let that was listed, but we shall file an affidavit.
We don't have the status report, nor do we have the evidence before us.
So let them fix it after 27.
Yes.
Page 27.
Yeah.
This is a key filing number.
Yeah.
What will you do?
Yes.
We have it some other day after.
Fair enough.
Yes.
After a week or so.
Let's have it after the 27th because the hearing is Manoj.
after a week means it will be.
No, but on the next date of the committee is 27th, have it afterwards. That's all I'm saying.
No problem. No
Second
problem.
week of May, your losses may have.
There is a very humble request, but they have filed an alleged compliance report. We wish to not put on record a few objections.
We have nothing.
No. What I say is this, we want to file a very short 3-page description of compliance, alleged compliance. We'll do it within that 1 week period.
I want to go for the committee on.
That is one of the reasons, Your Lordship, we have not been able to present ourselves in front of the committee also.
That is.
Well, then we'll have to go back into the issue. Let the committee decide. First,
Let the committee direction was that you must communicate us. You did not. You are not carrying out the committee's direction also.
What do we do now?
So, Your Lordship.
My lords, there's also a small problem with the last committee direction, which is that the committee has said that in 24 months, the monies between 2008 and 2016 may be paid. So, my lords, in 2 years, and there's no schedule for it or any of it.
No, as per the office. Just one office report brings us at the.
Yes.
Portal. Yes. Pura portal. List on 27. List on.
Second week of May.
Second week of May, Manoj? Yes.
Liberty to file may not.
Let's see whether we have complied or not. Let this be at the committee.
No, we can also take out objection to this.
1 minute, gentlemen, please. After 20, can we have it on 29?
Yes, Your Lordship.
Election day, Manoj.
Then a week there.
Week thereafter, Manoj.
We'll have it on 6th of May.
6th of May.
May another request, apart from the objection to the compliance, but the committee, headed by Honorable Justice Indu Malhotra, says, in paragraph.
Whatever it is, we know we have.
The only thing is, that we are not getting an opportunity to represent ourselves.
We'll wait now. After 2 weeks, nothing.
We will put it over there because the committee is supposed to.
Have you got some money or not?
Not yet.
Some money you have got.
Some employees, some not received.
Manoj, between.
See, that means process has begun.
Manoj, employees.
Very wrongful process,
Manoj,
there is a base of.
They are not adopting.
this is not going to get resolved like this.
We will put it in our Milord.
4,794 crores are disbursed.
No, disbursement only rightful dues.
There's no direct.
7th is election. We may take it on 29th.
6th May, Malaj.
6th
6th is May.
Let it be on 6th.
Obliged.
No problem.
6th May, and you move application.
Yes.
If you are not heard by the committee.
Yes.
Or if you have no space for the lack of direction whether you can appear or not, you move appropriate application.
Correct.
Before the committee itself.
No, there was a direction that the committees should be heard.
No, no, your lordship is, I will move an application. Your lordship
We'll
is.
move an application. So have you tried to address the committee?
Sometimes we'll have our thinking.
First time you are committing that we are not heard, we are without even making any effort.
No, now your lordships, Malaj, are giving sound.
There was direction that they will intimate us. And this is specific direction which was not carried out.
For this siege advice.
Anyway, let us come back on 6th of May, we shall see.